And Rebecca, good morning, everyone. We're so glad that you're joining us today. My name is Trisha Ravenhorst. I'm one of the attorneys at the South Carolina Coalition Against Domestic Violence and Sexual Assault, and really excited to be here with Rafaela Rodriguez today, and on behalf of NOAP to create this conversation with you. And so I'm going to let Rafaela introduce herself, and then, of course, if Rebecca, y'all have any housekeeping before we get started.
Okay. Hi. Hi, everyone. I'm Rafaela Rodriguez. I am Assistant Director here at the National Immigrant Women Advocacy Project at the American University of Washington College of Law. We're very happy to be here. Hopefully, this training will be helpful for everyone. And let us know if you have any questions. We would prefer that you put in the chat or actually open your mic and just ask the questions. And we will start from here. Rebecca, do you
And this
have
is,
any? Yeah.
I was just going to share that this is being recorded. It'll be shared following the presentation as well as the slides. As Rafael has shared, please use the chat for questions or feel free to raise your hand. And we will have a few, I think, opportunities for some discussion-based questions too. So thank you.
Okay, so this webinar today is supported by OVW, the grant on the Office of Violence Against Women at the Department of Justice, and the opinions, the findings, and the conclusions that Tricia and I say here are of ours, are from the authors, and does not necessarily reflect the views of the Department of Justice and the Office on Violence Against Women. So we already introduced ourselves. I just want to talk a little bit about what we do as NEWAP, as the National Immigrant Women Advocacy Project. We have a variety of resources that are available to you. We have a new app, the new app web library where you can find our director of service, our public benefits map that we are going to talk about today, demographic information about immigrant population in your state, and other materials as bench card toolkits, legal research. We also provide technical assistance, case by case, policies and strategies. It can be either from Zoom, email, or phone. Like, just reach out to us, and we can definitely schedule a conversation with you based on your question. We also provide, as we are doing here today, trainings and webinars. And we also have our community of practice as well that we are going to talk a little bit about later. Well, some of the topics that we cover are like legal immigration remedies. We talk. A new app is actually an organization that is like has expertise in any topics related to immigrant survivors. So honestly, if you are working with immigrant survivors and you have any questions related to public benefits or legal immigration remedies, what type of case should you file, or VAWA confidentiality, or UNT visa certification, also interpreters and translation. So we are here for you. We are like a resource organization, and we can discuss any type of topic related to immigrant survivors. Tricia?
Yeah. So not only, of course, like call us anytime, we're here to provide, you guys are our clients and make sure that you feel supported. But another way in which NOAP supports all of us in the field is NOAP hosts what are called communities of practice. And so these are groups of people like sort of peer-to-peer support, as well as learning opportunities that happen in a virtual space around on a sort of monthly basis. So of course, like I'm in the family law attorney community of practice and have been for years. And I get to attend every month, and I learn amazing things and meet amazing attorneys who work in this intersection of immigrant survivors across the country. But for those of you who are victim advocates, we have one that's just for you. And then, of course, we also have ones that are focused on our system partners, as well as our judges. So we're really, NOAP brings people together across the country, and we hope that you are interested in joining one of these communities of practice. And it's just a really great place to learn.
Yeah. And now I think all the community of practice are meeting like at least once a month. So yeah, feel free to join us to register actually for one of the community of practice. It's it's we call like a membership based community practice, but there's like no fee or anything. It's just like a closed group, and you're gonna receive some materials that are just shared with the community of practice. So just yeah, make sure you check it out.
So for me, it's been a lifeline my whole career, and I hope you guys join. So today we're going to sort of, obviously we're trying to cover a lot for you guys because of course, like, those of us in the advocacy space, there's a lot we're supposed to know all the time. So we're going to try our best to give you an overview so that you can better able like to sort of work with survivors. So of course, like we're going to talk a little bit about the legal immigration remedies that survivors might be eligible for within the immigration space. We're going to talk about sort of the Violence Against Women Act's protections for immigrant survivors that are sort of unique to survivors of crime. And then we'll talk a little bit about how that intersects also in the family court with orders of protection and divorce and custody. Rafaela is going to talk a little bit more about things that are specific to Maryland today. So I'm sort of jealous here in South Carolina that you guys actually have some Maryland specific protections for survivors. And of course, like we'll remind you again how you can access us and all of NUAP's like really great materials.
Okay. So, so we always like to start about talking about like the immigration population in your state. Sometimes like this data are very surprising and not exactly what you were expecting. So it's really interesting to go a little bit further on what is the immigration population in your state. So in Maryland, 16% of the state are people that are foreign born. 54% of them are naturalized citizens, and 27% of them are legal permanent residents. And then 18% of these populations are temporary visa holders and undocumented immigrants. And this include like student visas, work visas, and undocumented immigrants as well. So Maryland has seen like a rise in the immigration population in the 2000s, and it's like a rise of like 98% of that immigration population from 2000 to 2022. And where they come from? 39% of the immigration population in Maryland comes from Latin America, like me. Uh, 18% of them are from El Salvador, which is expected. And then other from Central Americas, 7.6% from South America, 7.3% from the Caribbean. You also have a very large population of people from Asia, 27%. 6.2% of this 27 are from India, others from China, and you also have a smaller percentage from other countries in the South Central Asia. You can share in the chat with us. Do you think this like represents what you're seeing in your day-to-day work? Like are the clients that you are representing? And we have also 20% that are from countries in Africa, being like 90.9% also from countries from Western Africa. And you have also some smaller percentage from other continents in the world, like Europe, 8.5, Canada, 0.8%. The language spoken at home, 20.7% of the people in Maryland speak other language, speak a language other than English at home. And 37% of them are foreign-born population who are LEP, which means that they speak English less than very well. We'll go dive a little bit more on this data. The LEP population that speaks English less than very well, 26% of them, 26% of the naturalized citizens are LEP. 52% of the non-citizens are LEP. And then if we think about it, like what are the types, so this data is important to think about like what are the types of interpretation and translations that we are providing in our organizations, right? So if we think about like we always think like what is the language that is like most available for immigrant population, we always think about Spanish. But here in Maryland, the biggest LEP population is actually Vietnamese. The second largest is Korean, and then we have Chinese, and then Spanish is the fourth population. So it's honestly it's important to think about, and also let me know if this represents what you're seeing and what are the populations that you're serving in your organization.
So next, we're going to switch over to sort of doing a little high-level screening for the immigration protections that are available to victims. One of the questions, that is always asked throughout my whole career is like, if I'm, a non-citizen here in the United States and somebody has harmed me, is there a way for me to remain in the United States to participate in the criminal process, or are there ways in which, my immigration status can be protected, or I can remain in the United States and remain in the United States safely? So the good news is the answer to that question is yes. Yeah, so it's really neat. So I think like in responding to some of these sort of policy questions, Congress really early on, especially in its early days of the Violence Against Women Act, first created pathways for individuals who normally would be able to get green cards through family members. So they created what we're going to talk about, a process where people in abusive family relationships can leave those family relationships, but continue on their journey with their immigration status. And then we sort of progressed along in the 2000s, where there was an expansion of protections that Congress put into place for victims of violent crime and victims of trafficking that sort of helped encourage survivors to come forward and report and participate in the criminal justice process, and allowing them to both stay here during that and also reduce any fear that they had in coming forward, speaking with law enforcement. And then we're also going to talk a little bit about the special protections that were really some of the early protections for really immigrant children who, were really no longer safe with their families or their parents, and then the family courts deciding that it wasn't safe for them to return to the home country. So although we work in a very heavy space with victim services, it has been sort of a bright spot within the immigration space and within the victim advocacy space to let immigrant crime victims know that Congress has been thinking about them for a very long time and has sort of created pathways to more stable immigration pathways that allow them to participate and feel safer within the community. So what are those basket of immigration needs? So this is, we love this. I'm so thankful to NOAP for actually saving this graphic. It was created by the Department of Homeland Security and part of their trafficking campaign a few years back. And so this is available on the NOAP website. We hope you take the time to use the QR code. So for those of you who are working with immigrant survivors and you're trying to communicate to a survivor that there may be a safe immigration pathway for them. This graphic is a really quick snapshot of some of the things I'm going to go into a little bit more detail and sort of really show you the humanitarian and victim-based immigration programs that exist within the U.S. immigration system. And again, this graphic always makes me happy because I do feel like it's like this is our basket of help that we can provide as both advocates and immigration attorneys. You can go ahead and switch it. So we're going to talk about, the first one we're going to talk about is, Rafaela, whenever you're ready. Great, thank you. So first of all, we're just going to do a real big overview. So largely when you're thinking like stepping back is like the immigrant survivors or immigrant victims of crime that have been, that maybe have immigration protections available to them are, then these are sort of the general list of crimes. This list of crimes is largely from the U visa statute, which we'll talk about. But when clients are victims of one of these crimes, and of course, like, we're here to talk about domestic violence is one of the qualifying crimes for many of these protections. And so, so if your client is a victim of, course, domestic violence, and we're going to talk about what that means within the immigration system a little bit more. But also if the clients that you're working with have been victims in the past of some of these other crimes, or they're co-occurring crimes, it's going to be really, really important to sort of identify what types of crimes they've been subjected to, and not just and those that they've been subjected to, but also those that are being investigated. So again, the ones that we of course work with all the time are domestic violence, all the sexual assault and sexual related crimes. Of course, trafficking, we're going to talk about a little bit today. And then of course, in the the highlighted section with the parent perpetrated child abuse, neglect, and abandonment. We also want to evaluate children who might sort of, and these are sort of like, there are protections under the special immigrant juvenile, which we'll talk about, for children who are sort of identified in the child welfare space of being abused, neglected, or abandoned by a parent. And so it's really, we want to give you just a broad aspect of like all the things that we'd be looking for and screening for. So first, we're going to talk about one of the first immigration protections that was created for immigrant survivors, as sort of I mentioned. So for those of you who don't know, like, largely the U.S. immigration system is generally what we call a sponsor-based system. So in order to be able to come in and live and work here permanently, you either have to be sponsored by an employer or a family member. And of course, if that employer or family member is abusive in some way, that can be really scary, because of course, like the ability to move forward with a green card or maintain status is dependent on that family sponsorship. So recognizing that sort of built-in control pattern, Congress created what we call the VAWA self-petitioning requirement. And it's a way in which for an individual who is subjected to battery or extreme cruelty, we'll talk about that in a second, to actually kind of move around their family sponsor and actually self-sponsor themselves. So they can choose to leave the relationship and no longer have to rely solely on their U.S. citizen or green card holding or permanent resident family member to sponsor them. So the VAWA self-petitioning, when you hear immigration lawyers ask this question all the time, we're gonna be like, so are they married? So, first so the relationship matters. So like first we're looking for the relationship. So the relationship between the abuser and the survivor has to, of course, be a marital relationship or a parent-child relationship. So we'll ask, like, what's the relationship? Are they married? And then the second thing we're actually then asking is, like, what is the status of the abusive person? So if the status of the abusive person is a U.S. citizen or legal permanent resident or green card holder, then we are going to be really looking hard at whether or not the person qualifies to apply for a green card through the VAWA self-petitioning process. But it does require those relationships, and it does require that the abuser have this legal status. So then once we get sort of that screening, though, and I wanted to say this, but then we're sort of like, the individual, in order to sponsor themselves for a green card, still has to prove that when they married the person, it was in good faith. Like, when I entered into this relationship, it was because I meant it, and it wasn't just to get a green card. So we still have to work with the survivor to collect a lot of the information about how they met, why they're getting married, all the things that they lived together. But we're also going to be exploring, like, what is the abuse that they were suffering. So, so in a classic sense, of course, we're going to be looking at, has there been battery? So that's physical harm, threats of physical harm. And we would be sort of working with the victim about all the, getting them to tell the story about any physical harm they've experienced or reported. But as a bright spot in immigration, the U.S. immigration system not only recognizes domestic violence as a physical harm, but also actually recognizes that it could also be simply a pattern of extreme cruelty. So when I'm training on VAWA self-petitioning, I'm always going to be looking at if there's physical threats or harm. But, when all of us are trained in the power and control wheel, all of the different types of harm that our survivors experience, like financial harm, psychological abuse, isolation, all of those types of things, the U.S. immigration system through the VAWA self-petitioning process also recognizes that as abuse. And so for survivors, they get to tell their full story. They don't have to have physical harm, and they don't have to have reported to law enforcement. So that's really, really amazing. I just wanted to point out, though, that so the VAWA self-petitioning process is when the person is applying for the green card for the first time, or maybe their husband or wife has sponsored them, but it's pending and they're worried that it's going to be revoked. And so that's what we're talking about. But there's also a situation, just wanted to point out that when people get green cards through marriage, and when they get their green card, they haven't been married for 2 years. They only get a green card for 2 years, and it's called a conditional permanent resident. So just to keep it real simple for you, like when somebody calls and they say, I have a green card, my spouse sponsored me for that green card, I always ask one question: is the card good for 10 years or is the card good for 2 years? If the card is good for 10 years, that means they're a permanent resident, and any break in the relationship isn't going to impact them anymore. So you can reduce stress. They can kind of move along. They can leave the relationship without having their green card go away. But if somebody only has a 2-year green card, I consider that kind of an emergency case because there are some really strict timelines on how that person can renew their green card. And the good news is the Violence Against Women Act allows the victim to, again, go through that process by themselves and not have to depend on their abuser to do that. So we've seen a huge spike in those cases recently. So I just wanted to spend a little extra time on that. Okay, Raphael. So the other green card program that's available for survivors is called the Special Immigrant Juvenile Program. So this is a specific remedy. So one, children under U.S. immigration law are actually defined as unmarried and under 21. But if the child is in, basically, this requires that the child be in front of the family court in your state. So if there's a child in family court in your state and the family court judge, in looking at this child's circumstances, determines that one, the child is under the jurisdiction of the family court. If the family court determines that the child has been abused, abandoned, neglected, or something similar, by at least, and then also determines that it's not, that reunification with at least one of their parents is not a good idea because of that abuse, neglect, or abandonment, and determines that the child should not be returned to the home country for any reason. So if a family court issues an order that says those three things, the child can take that court order and apply for a green card through the special immigrant juvenile process. So for those of you who are working with children that are disconnected from one or both parents, or one or both parents is accused of abuse, neglect, or abandonment, having sort of this analysis, or make, like they're already in a family court proceeding, like having a lawyer look at this carefully, or perhaps they need to be put in, there needs to be a family court action initiated so that a family court judge can take a look at whether the child qualifies for this particular benefit. So that's huge, especially for children who might, course, be in the child welfare system, or children who are with, have one supportive caregiver, but another caregiver who is causing harm. So now we're going to switch from, those are the two big green card programs that we talk about. We're always looking for survivors who are qualifying for a direct path to green card. But of course, we also know that a lot of survivors are victims of abuse by people who are not married to or do not have legal status. So the U visa was created to sort of help victims of a larger group of qualifying crimes. So that slide that I showed earlier, that was the list of qualifying crimes for the U visa. So the interesting thing about the U visa program, though, it was largely created sort of as a sort of, I call it like a carrot, sort of like it's a carrot and a tool for victims to sort of like feel more comfortable coming forward and reporting the crime to law enforcement, and not only reporting the crime, but remaining available to help in the investigation and prosecution of the crime. So when we're looking at the U visa, the relationship between the abusive person and the victim is not as relevant, but we do have to ask, are they a victim of one of those qualifying crimes? Has the case been reported to some sort of investigating agency? And of course, like we have to ask, like, has the victim been helpful? Are they being helpful? Are they going to be helpful in the future? So, so sometimes, like when a survivor's like never reported anything that's ever happened to them, the U visa may not be something that's available to them right now, but we're sort of looking at that. The other U visa requirements, so obviously we have to be a victim of a qualifying crime. We have to be involved in sort of investigation or prosecution in some way. And then of course, as immigration lawyers, when presenting their case, we have to show that as a result of the victimization, they suffered substantial physical harm or mental abuse. And so we sort of present that. The toughest thing about the U visa, and you guys are in Maryland, so it's a little less tough than it is in South Carolina. But the U visa, in order for a victim to be able to apply for a U visa, they have to have an investigating agency, prosecuting agency, or judge sign what we call the U certification form. And so that agency has to sign, that has to be willing and able to sign a form verifying that the victim is, again, the victim of a qualifying crime and is being helpful with the investigation or prosecution. Sort of fun fact on the U visa stuff, though, obviously traditional law enforcement, prosecution, and judges are U visa certifiers, but also, and maybe Raphael can correct me, in Maryland, but like especially here in South Carolina, our Child Welfare Service can certify the U visa, as well as like agencies like the EEOC or the Department of Labor. So there are some non-traditional investigating agencies on the civil side that can be very, very helpful. And of course, like the U visa doesn't require that there actually be criminal charges or that criminal charges be successful. And the crime could have happened 5 years ago, 10 years ago, or yesterday. So the U visa is sort of expansive. It's we always want to be evaluating current victimization as well as past victimization. And so the U visa, okay, so that, okay, here's our first poll. Are you guys in on
Okay,
this for me?
yeah.
Yeah. So yeah, so before we move on to the next thing I'm going to talk about. So again, does DHS recognize human trafficking? Can it occur in a traditional domestic violence or interpersonal relationship? Just give you guys a few more seconds.
Give it a few more seconds and then I'll end it.
That's almost everybody.
Almost everybody.
Yep.
Okay.
Well, you guys are so smart, of course. Yes, the answer, it is true. And actually, over the course of my career, I've been very successful in making that argument, mainly within the immigration space. So for immigrant survivors, screening for trafficking is really, really important. And the reason is, and we can move to the next slide, like screening for trafficking is really important because, you know, the U visa that I just talked about, you know, is available for trafficking victims and other victims of crime. But because they only issue 10,000 U visas a year, what do you think the waiting list is now, Rafaela, for the U visa?
For the U visa, I think it's like 10 years.
Yeah, so they can
11.
only approve 10,000 a year, and there's definitely over like 350,000 people waiting. So the U visa, of course, is very, very important, but it is not it doesn't, you know, it is not something that is immediately helpful in some ways. But the T visa was very much like the U visa. So both the U and T visa were created to give the person initial 4 years of legal immigration status based on the fact that they're victims of a qualifying crime. So the U visa, of course, is that whole list. The T visa that was only available to victims of trafficking in persons, both sex trafficking and labor trafficking. And so it's really important. You're like, why is that important to identify T visa? So although they only can technically issue 5,000 T visas a year, but they don't generally reach that number. So the processing time for getting a T visa is much, much lower. It's much, much faster. Also, when somebody gets a T visa, they not only get legal status and a work permit, just like they would with the U visa, but they also get access to full public benefits, which is really amazing. And so the T visa is, you know, much, much sort of has more benefits. It's quicker and it has more support for survivors. So when we can and do a trafficking analysis, it can really be game changing for a survivor. And so again, so that path to work authorization and permanent status is much faster. So we always want to be screening for trafficking as well as traditional domestic violence and sexual assault. Next slide. Yeah, so the only little last thing we want to do, the other reason why identifying the presence of trafficking is really, really important, because unlike all of these other programs we're talking about, trafficking survivors also have access to a special immigration status called continued presence. What's unique about continued presence is that the application for continued presence, which is this sort of legal status for lack of complicating things. But what's interesting about it is the survivor does not apply for the benefit. It's actually law enforcement that submits the application for continued presence for the trafficking victim. That can either be done directly by federal law enforcement authorities. So we work a lot with Homeland Security investigations and the FBI to prepare and submit these packets. But if you're working with a survivor who's primarily being supported by a state or local law enforcement agency, that state or local law enforcement agency can reach out to the victim advocacy team at Homeland Security and the FBI for support in submitting a continued presence application for a victim that they're working with. What's amazing about continued presence is that if it is accepted, right now, this last time I've talked to them, like the processing times can be like 6 to 8 weeks. Once Homeland Security or FBI like sends the packet up the chain, and then it gives the person 2 years of legal status, work authorization, and access to public benefits, and basically is a bridge and gives them time to file that T visa application and remain safe while they're here. So it's really amazing if that's appropriate for your survivor. And again, just sort of said that, yeah. So it's a 2-year thing, and it's really like it's been a nice bridge. for victims and is unique. But this is the bright spot in Maryland. So I'm going to kick it back to Rafaela to talk about U visa certifications, which makes me very jealous.
Okay. Well, so Anna, I definitely saw your question, but we are going to talk about the certifying agencies in Maryland now. So this is something that we are very excited for. We have followed the bill very closely, and we were very happy when this was approved. So Maryland now has a U visa certification law, and we have been working in Maryland and with Rebecca for a while now. And I remember that we did a survey with actually victim advocates and other organizations in Maryland about different things about public benefits, but also about U visa certification. And one of the complaints that we received is that it was very confusing, that a lot of officers didn't know like how the process would work, or like some agencies had like other steps like there was not there was not in the federal law about how to sign a new visa certification, what are the chain of command that was necessary. So this was very confusing for not only victim advocates but immigration attorneys working with U visa in Maryland. So when this law was signed, we are very excited. It says enacted in April 2022, but it's in force now here, I think 1st of October. So the Maryland U visa certification law, there's nothing very like completely new. It's a law that mirrors the federal law. So the certifying agencies in Maryland are the same ones as the federal law, but you have a list here who can certify, and the law and the Maryland law also says explicitly what is the list of certifying agencies. So who can sign a new visa certification in Maryland? State and local law enforcement agencies, the state attorneys, the child, and as Tricia said, Child Protective Service can sign, Adult Protective Service can sign, Commission on Civil Rights, and the Maryland Department of Labor, and etc. But also any other authority that has the responsibility of detection, investigation, or prosecution of a qualifying crime or criminal activity. And that one also includes judges. So judicial certification is also allowed by Maryland law, because as I said, it mirrors the federal law where judges also are one of the certifiers for U visa. Who can request the certification? So the victim, of course, can request the U visa certification, but also the victim's parent, the guardian, or next friend if the victim is under 16 years or incapacitated or incompetent, and the parent, the guardian, or the next friend has been helpful with the case. Who can also request the certification? The attorney, the victim advocates, or the representative, of course, like in name of the victim. So, determining helpfulness in Maryland is the same thing as a federal law. Helpfulness is considered, like the victim is considered helpful if the initiation of helpfulness, the individual has not unreasonably refused to cooperate or unreasonably failed to provide information and assistance reasonably requested by a certified entity. So we have a list, and I think like Stacy or Nupur can put it in the chat. We have a list, for example, of what is like a checklist of helpfulness, like several examples of what is considered helpfulness. So calling 911 is helpfulness. Like providing a statement is helpfulness. So talking with the police about what the crime it is considered helpfulness. And one of the good things, and this is this is one of the new things in the Maryland law, is that if the U visa certification is denied, it is required by the certified agent written explanation if the evidence does not support the issue of certification. So if they decided not to sign the certification, they need to have a motive why they're not signing that certification. Maryland U visa certificate. Oh, so It's also they have established time to respond, which is great. This was also one of the things that we identified in the survey that we did in Maryland, is that it was taking too long. Like sometimes you would just request a new visa certifications and never hear back from the officer again. So now they do have established time limit to respond, which is 45 days or 7 days if the victim is in removal proceedings. As I mentioned, Maryland statute adopts and follow the federal guidelines, so they do authorize judicial certifications. As Tricia said, also there is no statute of limitation. You can request a U visa certification at any time. And what is also not required, and this is explicitly also in the Maryland law, is a current investigation, filing of charges, a prosecution or conviction. We know that this has happened in other states, but also has happened in Maryland, that a prosecutor, for example, does not want to provide a U visa certification until that case is closed. This is not required. This is not, and this is not what Maryland U visa certification law says now. You don't need a conviction, and you don't need a prosecution to sign a U visa certification. Okay. So, do you have any questions about the Maryland law? Just let us know.
Yeah, and then while you'll have questions, I just like from a practice tip perspective, like with this cooperation element. So of course, like, as victim advocates, like, of course we're first and foremost, we center what a survivor is interested in doing and cooperating and not cooperating and approaching law enforcement. Of course, it's a very personal calculation. But again, I also have worked with so many victims, and of course, like in the course of an investigation or prosecution, they have many emotions, like they want to be involved, they don't want to be involved, like a lot of it's a big roller coaster, which is totally normal and totally understandable. So I think for immigrant survivors, though, making sure that they understand sort of the possible availability of a U visa, like what it means to be helpful, what it doesn't mean to be helpful, can really be helpful, can be grounding. And then I sort of encourage my clients, like if they're sort of again on that roller coaster of feeling scared and interested in being involved in this sort of investigative process, just sort of like have a conversation with you as an advocate or as an attorney to talk about those feelings and sort of and help sure. I think I get a little bit sad when survivors feeling anxious and they call up the prosecutor and they're just like, I want out. And then that sort of ends it and can end the U visa eligibility at that point. So I think like having a open and frank conversation with your client about making sure that they're able to process their feelings and their fears before making a big decision to communicate their lack of interest or continued interest in an investigation. It's just important, just giving them that space and giving them the support and information they need.
Yeah. Trisha and Rafaela, there's a question. Can they, I guess the victim, appeal the denial of the certification?
I think they can, especially like if what I know they can appeal if like the decision's not made in 45 days. I don't remember exactly where the appeal goes, but I will check. So Nupur, can you take this question, and I will definitely like follow up with you by the end of this webinar. But they can appeal. I just don't know who is like the next who they can appeal to.
And Rafaela, isn't it also with the new law, if a certification is denied, the reasoning must now be provided, correct?
Yeah, that's what. Yeah, yeah. The denial. They need to have like a written explanation why they are denying that U visa certification.
Which prior to now starting 10-1, that wasn't happening.
It wasn't happening. Yeah, this is actually new for Maryland. Like this is new. We have other states that also have that state law that actually requires this written explanation, but not all states require it. And federal law also doesn't require it, which is like so somehow unique to Maryland and some few states that now requires a written explanation why the certification is being denied.
Thanks.
Okay, so we do have so let's now like test your knowledge of what we just talked about and Trisha explained. So we have a scenario here and we have 3 polls for you. So I'm gonna read the scenario and then we are gonna ask the questions. So Clara met Eduardo, a lawful permanent resident, when he came back to his hometown to visit his family in El Salvador. Eduardo started dating Clara, who was raising her 9-year-old son, Miguel. After Clara became pregnant and gave birth to a baby girl, Lupe, Eduardo decided to bring Clara, Miguel, and Lupe to the US to live with him. When they arrived in the US, Eduardo took Clara, Miguel, and Lupe's passport and became physically and sexually abusive of Clara and abusive of Miguel, who tried to protect his mother from Eduardo's abuse. Eduardo also physically beat Lupe when he said that she misbehaved. Within a year following their arrival in the US, Eduardo forced both Clara and Miguel to work for his family's business and never paid them for their labor. One night, when Miguel was 13 and Lupe was 5, Eduardo's rage led to severe beating with a belt of Miguel and Lupe. When Clara intervened to protect the children, Eduardo strangled her until she passed out. The neighbors called the police for help. Clara talked to the police when they arrived. The police arrested Eduardo for attempted murder and child abuse, took Clara to the hospital, and placed the children in the care of the state. Okay. So our first poll here is, what forms of immigration relief would Clara qualify for? Clara is the mother. Waiting for you. Gonna give you a few minutes. Yeah, so the options are the U visa. She would qualify for to be included in Lupe's VAWA self-petition, T visa, or D, all the above. Think we can share, Rebecca. Okay, so 79% of you decided that was like all the above. And yeah, that's correct. So Clara would qualify for a U visa. She was victim of a crime, like she was sexually assaulted, abused. She was also like Eduardo also took their passport, right, and made them work without them getting paid. So she would also qualify for a U visa. And Lupe was also victim of child abuse. So she could also qualify for a VAWA self-petition. So and she could be included in Lupe's VAWA self-petition as well. Okay, let's do the other one. What forms of immigration relief would Lupe not qualify for? So Lupe is the baby girl. So Lupe wouldn't qualify for VAWA self-petition, U visa, special immigrant juvenile status, or a T visa. Okay. We have, let's go. Okay, so okay, so this was split. 44% thinks it's SIJ, and then 44 T visas, but also some people think it's VAWA subpetition or U visa. Well, Lupe as I said, Lupe is the baby girl. The baby girl would not qualify for a T visa. She wasn't trafficked. She was not she was not working, being forced to work. She would be eligible. She would qualify for a special immigrant juvenile status because Eduardo, her father, is been abusive to her. So she was a victim of child abuse. So she would qualify for a special immigrant juvenile status. She would qualify for a U visa on the same reasons. She's a victim of child abuse. She a victim of a criminal activity, so she would qualify for a visa. And also she would qualify for a VAWA self-petition because she's a daughter of a U.S. citizen. So U.S. citizen, no, lawful permanent resident, I think Eduardo is. Okay, next one. Last one. What forms of immigration relief would Miguel qualify for? VAWA self-petition, a U visa, T visa, or SIJ? Okay. Let's wait a few more minutes. Okay, let's end the poll. So the majority decided that he would qualify for an SIJ, then a T visa, then U visa, and then a VAWA self-petition. Okay, so Miguel would not qualify for an SIJ. And the reason why Miguel wouldn't qualify for SIJ is because he is the stepson of Eduardo. So SIJ is only for parents. Stepsons and stepdaughters and stepsons cannot apply for SIJ based on the abuse of a step-parent. So he would not qualify for SIJ. He would though qualify for a T visa because he was working. He was forced to work. His Eduardo took his passport as well, so he would qualify for a T visa. But he would also qualify for a U visa on the same reasons. He was also a victim of trafficking, so he will qualify for a U visa. For VAWA self-petition, it depends, right? So for VAWA self-petition, like Eduardo is a lawful permanent resident, and like you can include stepsons in. He could be included in Clara's application as the stepson of Eduardo, but there is like one of the things that is not explained in this scenario is like, are they married or not? He could only be included in the VAWA self-petition, or actually, I think to self-petition himself, if Eduardo and Clara were married. If they were not married, then he would not qualify for VAWA self-petition. Okay. Okay, thank you. Anything, Tricia? Did I miss anything?
No, I just think like the practice tip here is I think that I have with my advocacy lens on and my immigration attorney lens on, especially working with children or, it's like the importance of like evaluating all of the remedies are really important. And just for you guys to know practically, like some people are like, oh, they clearly qualify for one of the green card programs. So we'll just do that. And so sometimes I think for me as an immigration lawyer, though, because each of these benefits there's sort of nuances. Like, so the first step is like, do they qualify? Like, are they the right type of victim and the right type of relationship with the right type of victimization? But also just for you guys to know practically, all of these, every single one of these benefits has a different process, has a different timing, has sort of different back end benefits, like how quickly can you get a work permit? Can you get public benefits? Like, are there little special rules? So I just being very honest, like as somebody who's done this work for a long time, I would probably do all the things all at once. And because I never know which one is going to stick and which one is going to go faster. And of course, like, I always try to make sure that each survivor is like standing on their own 2 feet legally. So like these things can take many, many years. So like we have had sad situations like where like the mom like gets ill and passes away before the application. So we sort of, so just for, like looking at this holistically and look at each individual member of the family, like, so even if like the case is coming into you as like the mom is a primary victim of DV, like making sure that the whole family is being evaluated can be really life-changing for a family and open up different options for the children versus the parents versus And that can matter, especially with this long timeline that these processes take. So I just want to give you that, like, like helping pull apart those storylines can make a big difference in a family's like safety plan.
Okay, and I think this is a good point of that you mentioned that you would apply for all of them at the same time, because
Yeah.
this usually is a question like, can you apply for more than one?
Yeah.
And yeah.
Yeah, it's a lot, but usually I was
Yeah.
like doing like 5 of them at one time. And it's like largely the same story. So like from an attorney's perspective, while there's lots of logistics and stuff, but most of these applications are now free for the time being. So like the filing fees are actually now free in this current moment. And so just sort of like, and I usually just send them all in at once. Yeah. And then whichever one wins first, I'm excited.
Okay. So a question for you now, guys, and you can answer in the chat or you can open your microphone. When a victim comes to your agency for help or to your organization for help, how do you approach what to do first? So, a question here. Would you be able to share the fees for these visas? As Trisha just mentioned, they have no fee right now.
Yeah, so all of the applications that we just discussed about, I mean, in general, like all of the applications that sort of surround the filing packages for each of these benefits are now zero fee. There's still some costs associated with getting those things ready, but that's been a huge change in the last few years to have those free.
Yeah.
So that's the answer. And if you're curious, like there's a fee schedule on the immigration website, you can always check.
Yeah, there's a fee schedule. And immigrant survivors actually like the whole process. The only point that they have a fee to pay is when they're applying for naturalization. Okay. So does anyone want to share, like when your victim comes to your organization, what do you do first to help them?
Mm.
Did I see anyone? Okay. So let's talk about safety through early screening. So one of the things that we are discussing, and I think through the scenarios we could see, is that you should be screening for everything, right? You should be talking to them and trying to identify, because of course, like a victim is not gonna come to you um, and say like, so I'm a victim of this crime and this crime and this crime and this crime, or even if that I am a victim, right? So this is like through screening that we need to understand their story and how and what type of immigration relief, or if any, they are eligible for. So it's important also for that reason, it's also important for you to understand the difference between the immigration options that we were just talking about. It's really important to document the history of abuse. This can change throughout time, so it's important to have that plan and also incorporate it into safety planning as well. So we also want to promote victim participation, and we should try to file the immigration case as soon as possible. But also, it's really important to have a strong case to file. So make sure you have all the evidence. Make sure you have all the story of the victim story. As we mentioned, just like document all the history of abuse. So it's really important, but it's important also to try to file immigration case before any protection order against the victim or family or a criminal court cases as well. It's important to file before a victim travels to a new location as well. And particularly when the victims are experience immigration related threats. Um, so it's really important to consult an immigration attorney. And it's really important not only any immigration attorney, but it's really important to also consult immigration attorneys or organizations who have the expertise serving immigrant victims. So they have the expertise working with VAWAs, Ts, and U visa cases. And this is especially important when victims have criminal histories, when they got arrested, when they have a removal order, a issue against them, or they have open immigration cases or multiple reentries in the US. So it's really important to check with an immigration attorneys before file them, especially if you have these cases. So we have received a lot of questions related to is it worth it to file a VAWA TNU right now? And the answer is like it's helpful. It's usually more helpful to have a VAWA RT or a visa case pending than not. So it's more protective because you do have protections, and we are going to talk about these protections. Um, Soon. So timing is also really important. You also should file well. We talked about how you should file well documented cases. You as a victim advocates, that you play a very important roles. You are the ones who usually are the ones who have trauma informed tools to interview victims, to understand their history, and all this abusive all the history of abuse is really important when file this type of cases as well as TNU. Um, it's also really important, and it's also really important when a victim has, for example, a new visa certification. So she has a document that is signed by the law enforcement saying that they are a victim of criminal activity and they are actually working with the police. So at this point, it's really important for a victim to have this type of documentation. So working with law enforcement prosecutors, it's also very helpful. So, and that's why it's also important, like, to identify immigration attorneys who have the expertise that we are talking about. And one of the ways that you can do that, I'm sure, like, you work with coalitions of domestic violence, you have your contacts. But if you don't, if you have a victim that is in a region, for example, that is different than the one that you work, or they are moving there, we have NEWAP has a directory of service. There we have programs like organizations all over the country, and you can sort them by zip code, by region, by city, by state. And we provide information about like what type of service this organization or attorneys do. If they have, for example, interpretation and translation, in which language they can offer. So you can definitely access our new app directory to and all the organizations and attorneys who are in our directory, they are usually experts in immigrant crime victims, so they have experience working with VAWAs, T's, and U. Okay.
Okay. So as a coalition attorney, I love talking about VAWA confidentiality two ways. So just as a grounding technique, I'm going to get into a specific part of VAWA confidentiality that protects immigrant survivors. But just as a grounding, so for all of us, of course, who work at domestic violence agencies, we are subject to our normal strict confidentiality rules through VAWA, which, as we all know, like, we cannot confirm or deny that we're providing or have provided services to a survivor, of course, unless there is a release from the survivor or there's a court order or statutory mandate. So of course, like, that's just sort of like 101 for all of us in victim services. And so of course, like, that's really important to just remember and ground, especially we get a lot of questions about, like, what if law enforcement or immigration enforcement comes to your program or asks you questions, like those same things that we do every single day about, thank you so much for your question, but I have these confidentiality requirements and I'm going to do that. But then this is interesting. So not only does the Violence Against Women Act put confidentiality requirements on us as victim service providers, but there are unique confidentiality requirements that immigration officers and DHS are also subject to with regarding to immigrant survivors. So the Violence Against Women Act is one of the only federal statutes that actually limits immigration enforcement when somebody has been identified as an immigrant survivor. So and so that's kind of really important for you to know, that that our federal law enforcement partners actually have their own requirements. And so we're going to talk about that. This actually really helps. So again, survivors are coming to us with a lot of fear. I think the normal fear is like they're afraid, like, if I report the crime or file one of these victim-based visas, a lot of survivors are like, will my abuser know that I filed a VAWA self-petition or a U visa? The other question we get a lot of times is like, my abuser is constantly telling me that they're going to call immigration and they're going to say all these bad things about me. And then based on these like lies that they're telling, like immigration is going to come and take away my visa or have me deported. And so that's a huge fear. And then of course, the other fear that we talk about all the time is like, if I go to the courthouse or if I go in a particular location, will I come to the attention of immigration authorities? So those are usually like the three big fears that I usually get that people come to me with. And the Violence Against Women Act answers them in a couple ways. So one, which is really interesting, is the first one. So our federal law enforcement partners are actually prohibited from disclosing. They are not allowed to tell anybody that a victim has filed for one of the visa programs that we just talked about. So you can reassure them that federal law prohibits the federal government from telling anybody that one of these applications has been filed and revealing the contents of that. So that really helps bring down the temperature. So we can file these in secret and nobody, they're not allowed to tell anybody. The other really interesting thing is that immigration is also not allowed to rely on any information provided solely by the abuser or their family member to make sort of a negative decision in their case. And of course, and that not only extends to those who, that protection extends not only to those who have filed those visa applications, but to all victims who've been abused by a spouse or a parent. And of course, those who are also in the process of applying for a UNT visa. So I think it really does help, like when I tell survivors that, like, if their abuser, he or she is threatening to call immigration and say things against them, that again, immigration is not allowed to use that information as a basis for a negative decision or an enforcement action. So that's interesting. And then of course, the last piece, especially it's been in the news, is like there's been some changes in ICE policy regarding like where immigration enforcement officers can do sort of enforcement action generally. But the Violence Against Women Act statutorily protects all victims of the crimes that we talked about. And before immigration authorities can take an enforcement action at certain protected locations, and that includes domestic violence shelters, family justice centers, rape crisis centers, sort of the list of things that we do every day. It also includes the list of protected victim locations, also includes courthouses when the individual is there at the courthouse seeking protections, like an order of protection, or is there for the crime. And so before it doesn't mean an immigration officer can't attempt an enforcement action at one of those locations, but before they come to our places of business or to a courthouse, they have to get supervisory permission, and they have to verify that they did not use abuser provided information as the basis for the action. So those are just some real pause points that the Violence Against Women Act statute actually embeds in the law and are still in place today. And then, of course, there's a little note on there, like if the federal immigration, if the federal officers violate that, they can actually be subject to their own penalties and have to pay fines. So I always say, like, sort of like if you were approached by a federal officer, asking them, hey, just want to make sure that have you made sure that you're following your VAWA confidentiality requirements? We don't want you to get in trouble with your supervisors or have to pay a $5,000 fine. So that usually creates an opportunity for a pause, a conversation to let them know, hey, did you know that you were at a domestic violence shelter? Did you know that we're at the courthouse to get an order of protection? I just want to make sure that you knew that this person is a victim and that you might need to have done a little bit more work before you do whatever you're here to do today. So that's a friendly reminder that we each have these confidentiality requirements. You'll remind them of yours and you'll remind them of theirs. So, and everyone's like, so obviously, like, talking, remembering that we have our confidentiality and they have their confidentiality requirements is not an easy thing to articulate when you are like faced in an emergency situation or an unexpected situation where you have a law enforcement officer asking you lots of questions in a high stress environment. So so NIWAP has been amazing. They created this little QR code, but it's an expansive toolbox that sort of helps us have sort of letters in our pocket or have be able to provide survivors with a letter in their pocket to be able to calmly communicate to an immigration officer that I am a victim. I do have protections under VAWA, and I'd like you to know that so we can slow down whatever's happening here today. So obviously, this is like for you guys to look at. Our toolkit is much longer, but we wanted to give you a little bit of a sample. So in this packet, there are a series of template letters that your agency can use to sort of give a victim like a letter from your agency that sort of they can decide on their own to provide to somebody so identify, yes, I'm a victim of one of these crimes. If true, like I'm actively working with a law enforcement agency right now on my case, or I've filed something, and it kind of helps calmly help communicate to that ICE officer that the VAWA confidentiality protections are in place and that there needs to again be a slowdown and a conversation again of what's going on. And this has been really helpful. Victims being able to communicate with ICE officers if they are in deportation proceedings or have ICE check-in appointments or come to the attention. Here in South Carolina, being able to communicate these things has in fact been effective and has created opportunities for good conversations with our ICE partners.
Yeah, and I just want to say, like, so these letters are available to you on the New App's website. And as you can see, like, you can, like, this is like a simple letter, so you can change the way that you want. You have space, like, to, of course, put the name of your organization, the name of the victim, any personal information as well. If you have a victim, for example, filing for a U visa certificate for a U visa, and you have contact with law enforcement, signing the U visa certification, it's also really important. We have samples for law enforcement, so maybe if you have that relationship with your law enforcement, to provide them the simple letter so they can actually sign the letters as well. There is one that is just for law enforcement and prosecutors. So because like a letter that is signed by the law enforcement is also could be very important. And also make sure if you have a victim that has a U visa certification, that she would also have like a copy of the U visa certification with her.
Yeah. Next slide. And I think this becomes I think I'm going to switch to you. Yeah, I think that the reason why this is really important again, because again, this is obviously like especially survivors who are in deportation proceedings or at risk of deportation, like this sort of interaction with ICE, of course, is very scary and very high stress. But again, there are specific ICE policies in place for victim and witness protections, and it's important to be able to sort of like help a survivor identify themselves as a victim who has these protections, because it really can't guarantee that the person's not going to be removed, but it could definitely like slow down the conversation and create space to make sure that the victim's allowed to continue to participate in the protective things that they're doing or the investigation or prosecution that might be going on.
Yeah. You have a question, Earl?
Yes. First of all, good morning, everybody.
Good morning.
I would like to know who has access, who are the only people that have access to these letters?
So this letter's on our website. So you can, so what you have on the, like, everyone can access the letters. Like, we have the link there, like they're an open link, so everyone can access. But we are actually advertising the letters for victim advocates and attorneys and immigration attorneys that work with us. So this is the way that we are like distributing the letters and making them available.
So basically anybody can have access to it.
Well, but the letters are simple, right? So there's and what we have there, you can see the package that we have there. We have the letters, but we also have like the current policies that are in place right now. Mm-hmm.
Right. Okay.
Yeah. So I think it's just a tool, a communication tool in a high stress situation. And so like, obviously the victim can choose to communicate this or not. That's be up to him or her. right? As agency. And of course, like we were working on safety planning things like, so if, for example, like the client that you're working with was nervous that might something emergent might happen, like something unexpected, like some of our advocates are sort of like getting released, like kind of releases in place ahead of time, just like you would. So like emergency contact. So like, if something happens where you are placed in detention, who can we contact, who can we communicate with, and what level of information. So that might be, there might be, maybe you have this letter sort of in the office, but having, talking with a client about what kind of release of information you might want to have on file so that you could call a family member or an attorney or reach out to the law enforcement agency to let them know that like there's this like maybe immigration enforcement involvement. So yeah, so I think that these letters are a tool for the survivor to use on their own, but also a tool for you to sort of do some advocacy work, if the survivor wants you to do that on their behalf. Yeah.
Okay. So now we are going to talk about public benefits. We still have 20 minutes. Okay. So we'll talk about public benefits and how access to benefits and service grows as children and victims pursue immigration relief. So we are going to see that you have populations of immigrant populations that can access public benefits in different ways. So and I also just want to make a disclaimer from the beginnings that we do know that there's like some changes to public benefits and federal public benefits. And these changes are ongoing. So the information that we are going to share today is the information that is current today. About what are public benefits is available to immigrant populations, but we know this can change because agencies are actually issuing new guidance every week based on the new administration's guidance as well. So we are waiting for that. So, but the information that I'm going to share today is what is currently today. So we have services that are open to all immigrant victims of crime, abuse, and neglect, including children. And these are like legal service, family courts, interpreter and translators. Police assistance is also available. Shelter, transitional housing, available to all immigrant victims of crime, abuse, neglect, and including the children. Also, emergency medical care is also available. In-kind service that are open to all immigrants. This is one of the sections that is subjected to changes, and that's why I have this highlighted here. So all the things that are highlighted are still open to all immigrants. So child and adult protect service, violence and abuse prevention, victim assistance, soup kitchens, community food banks, shelter and transitional housing. These are in-kind service that are statutorily, so they are like actually cited in their statute as in-kind service. And in-kind service are usually open to all immigrants. So this continues to be open to all immigrants until further notice. Nutrition program for those requiring special assistance like WIC. Now, in the past, they were open to all immigrants. Now, it's on the discretion of the states. So now I think 49 states to offer WIC to all immigrants. There's just one state that I think South Dakota that does not offer WIC to all immigrants. It's not open to all immigrants anymore. So this is like, this could change state by state. But at this point, like nutrition programs in most states, including Maryland's, it's a service that is open to all immigrants. So a question for you, a true or false? So immigrants applying for benefits for their children can refuse to provide immigration or social security information about themselves. Is it true or false? I'll read again. Immigrants applying for benefits for their children can refuse to provide immigration or social security information about themselves. Let's see, is it true or false? Okay, I think you can share, Rebecca. Oh, so it's 50-50. Okay, so it's actually It's actually true. They can refuse to provide immigration or social security information about themselves if they are applying for their children. They should only provide information about immigration status and social security information about the children. They should not be providing any information regarding themselves if they are not applying for themselves. If they're applying for the children, the information that is required is for the children. Only information about themselves or the family is income information. Then you need to share with the benefits agency about income information, but not about immigration status, social security number. So this is why it's also really important. So I was going to say, this is why it's really important for victim advocates to accompany victims applying for immigration for public benefits. A lot of times, even benefits agents, they don't know and they start asking questions because it's in their form. So they start asking questions that they shouldn't be asking. So it's really important to have someone, especially now, um, especially now because things are changing and there's more uncertainty of what public benefits are. An immigrant can apply or not. So it's really important to have someone, victim advocates, accompany victims applying for public benefits, immigrant crime victims. So when the children qualify and their parent guardians do not, the benefits, as we just said, the benefits granting agency may only ask questions about the child's eligibility and not about their parents. So it's also really important for you to be there to help educate state benefits workers. We receive so many questions from victim advocates that are like, I'm applying for this benefits for my client. I know she qualifies for that, but the state benefits worker don't think they do. And this happens a lot. So this is why it's really also really hard for some immigrant victims like to advocate for themselves and say like to the benefit worker, like I am eligible for that benefit. So also like accompanying immigrant applicants helps children and survivors to get what they legally qualify and entitled to access, and also not sharing any information that they shouldn't be sharing as well. One of the reasons that they shouldn't be sharing, and one of the reasons also they shouldn't be applying for public benefits that they do not qualify for, is that state benefit workers, they are actually statutorily required to report someone who is applying for benefits that they are not eligible for, and this is considered fraud. And if they think there's an immigrant applying for benefits that they do not qualify for, they should report to ICE as well. And this is considered fraud. And if you have, for example, a pending application and you have a fraud reporting, this could really really impact and affect your application, the immigration applications. So they should. It's really important that you know what they know and you know what you're applying for them. And one of how can I know, right? Like a public benefits law is so complicated, and I completely agree. Um, that's why we created the public benefits map. You can check. There's two main sources where to check about the eligibility for public benefits. One is our public benefits map. I'm gonna talk a little bit more later. And there's a government website called benefits.gov. You also have a lot of information there. You have more public benefits on that website than in ours website. However, they are not very good on immigrant access to public benefits. So a lot of times they do cite like if you want more information about immigrant eligibility to this benefit, check this website, and then it's our public benefits map. But you should definitely check both to see if they are eligible or not. You should always carry documents with you, and documents from the HS that also suggest that they have eligibility. also any, and we also have screening charts on our website that provides like very summarized information about eligibility of the victims. Okay, so we have a list of immigrants that do qualify for more public benefits than other, and these are what we call qualified immigrants. And qualified immigrants, this is the list, actually, the whole list of who are considered qualified immigrants. So trafficking victims with T visas, VAWAs, lawful permanent residents, refugees, and ISLEs. Make sure that this is our people who actually receive the asylum, not asylum applicants. So Cuban, Haitian entrants, veterans, Malaysians, people granted conditional entry, person parole in the U.S. 1 year or more. So this is the extensive list of qualified immigrants. Qualified immigrants can access some federal public benefits depending on their immigration status when they enter in the United States, and whether some of the public benefits have higher requirements or not, and depending, of course, on what type of public benefits it's offered by the state. The most restricted programs are categorized as federal public benefits, state public benefits, or the federal means tested public benefits. So one of the examples of state and federal public benefits are like retirement, welfare, health, disability, post-secondary education, public and assisted housing, food assistance, and unemployment. They're all considered federal public benefits, and they can only be accessed by qualified immigrants. This is a partial list of federal public benefits and community programs that are open to the qualified immigrants, the list that we just discussed. So public and assisted housing, Head Start, post-secondary education and grants, adoption assistance, low-income residential energy. This is a list of public benefits that are open to qualified immigrants. So if you have one of the victims, one of the status that we are discussing, if you have a VAWA self-petitioner, if you have a T visa, they can all access this type of public benefits. So some of the changes that are going on right now, we had some programs that are now considered public benefits, and they were not in the past. So now some of the programs from HHS were now categorized as federal public benefits. And this is like programs like Head Start and other community and mental health service, which in the past were not considered federal public benefits, and now are considered federal public benefits, which means that now only qualified immigrants can access them. In the past, lawfully present immigrants could access them. Lawfully present is a category of immigrants that is like broader than qualified immigrants. But now these programs are only available for qualified immigrants. The guidance from HHS informs and acknowledges that federal government cannot force nonprofit to verify eligibility, but they also say that more guidance on this information is coming, it's forthcoming. So we are gonna wait for that too. As I said about WIC, now USDA, the Department of Agriculture, informed that state may choose to offer or restrict WIC, and one state has already decided to restrict WIC. The other ones haven't made any changes, so we're also waiting for that. And I just want to say that, of course, you know, there's like lawsuits going on, and there's changes that are like ongoing. So this is what we have as of today.
Yeah, and Rafaela, like Maryland is one of the states participating in the litigation around these changes. And as of last week, the judge entered an order enjoining these changes in the states that are participating in the lawsuit. So Maryland is one of the states participating in this lawsuit. So again, for you guys in Maryland, it's the status of these things. You guys will need to get some guidance. So it's an interesting week. It's been an interesting week.
Earl?
Yes, I'd like to know which state declined to go with the WIC program.
So that's why I'm trying to remember. Sorry, I did read this yesterday, read this yesterday, and I don't remember. I think it's South Dakota.
Okay.
Yeah.
Okay.
Um, so okay, so federal means tested public benefits are the most restricted public benefits to access, and then these are the programs that have like additional requirements. So, and they're all for like TANF, which TANF has a what we call the 5-year bar. So they usually qualified immigrants needs to wait 5 years to apply to be eligible to apply for that benefit. SSI, it's a very hard benefit for immigrants to qualify for. They must be lawful permanent residents, and they need to also have like 40 quarters of work credits while they work under the qualified immigrant status, and they are also subjected to the 5-year bar. So it takes a while for them to be eligible for SSI. Food stamps. Qualified immigrants who are lawful permanent residents are eligible uh, for food stamps if they also in some state they also have the 5-year bar. Medicaid and CHIP at the lawful permanent residency they can access. And adults, they can access Medicaid. Qualified immigrants can access Medicaid who also met the 5-year bar. You have states that have alternatives to the 5-year bar. Maryland is one of them. I don't think I have time to go over all of them, but we are going to share the slides. But just an example, there's no 5-year bar in Maryland for TANF because Maryland has provided state-funded TANF during the 5-year bar. So applicants and recipients of VAWA, TEAS, OTIP, continued presence, SIJ applicants, asylees, and refugees, they all can access TANF without the 5-year bar in Maryland because there is a state-funded TANF. Childcare, there's no restriction. SSI is the same in the federal law. It's really takes a while. So I'm not gonna go over this, but also because we do have the public benefits map available to you. All this information is there. You can do the QR code thing. Our public benefits map, we have it's a map that has like it's by state, we have the benefits name, and we have by immigration status. So if you have a client, you can check by the state that where they live, we can check by the benefits that they are eligible for and by the status that they are applying for or they want to apply for, or you were thinking which one should I apply for. You can always check what type of public benefits they will be eligible for. We also have other documents on public benefits in Maryland that we are gonna share with you after this training. Okay, this one, Patricia, what do you want to do?
Yeah, well, we only have 2 minutes left. So we had some other slides that we were going to work on today, kind of like, for those of you who are helping immigrants in sort of traditional protective order and family court cases. So I think the big takeaway for y'all to think about with, of course, like immigrants are eligible to seek protective orders in Maryland. And we want to make sure that they realize that they getting one doesn't impact them, but it also just in terms of from a safety planning standpoint, there's sort of like one of the things we want to make sure that people know is that violating an order of protection can actually be a deportable offense. And so it's really, really important for immigrant survivors who might, maybe somebody has filed for an order of protection against them, or maybe like we see this in South Carolina, there's pressure to agree on a mutual order of protection, but for immigrant survivors, it's a really big deal. They might not want to be subject to one, but that's important. But also the protective order process is also, you can move to the next slide. Rafaela, also like we talked, and I'll skip that. So I just answered that question for y'all. But we also want to know, sometimes in an order of protection, especially since all the immigration relief that we just talked to you about, like, going into family court, whether it's an order of protection or a divorce and custody case, may be an opportunity to sort of, if you can kind of do it safely and creatively, is like making, using the family court process or the protective order process to like make sure that the victim has access to all of their documents, has copies of everything that they need. And then there are creative solutions to making sure that that the perpetrator or the abuser is not like holding information or documents or passports and things that a client might need to stabilize and move forward and apply for benefits. And then of course, like we get a lot of questions, and that was just the last slide, and we can kind of go through it. But we also just wanted to point out, we get a lot of questions, like what is the impact of like getting a divorce on my immigration status? And of course, like, somebody who is married or whose immigration status is dependent, on on being married or being in a particular relationship. We always want to make sure that a survivor understands, like, what is the impact of divorce on like my pending applications for immigration that might be family based, because we get a lot of calls from survivors who are in the middle of their spouse applying for a green card for them. So we want to talk to them about that. And then we also talk about like the good news is like, what is the impact of a divorce on being able to apply for some of the benefits that we talked about earlier. It's been nice, like the VAWA, the Violence Against Women Act was updated, so people can actually get divorced and still seek a green card through the VAWA self-petition process, but as long as that you do it within 2 years of divorce. So there are some, talking to an immigration lawyer and a family court lawyer and having sort of that, having that strategy work together, both creatively and practically. And then also we get a lot of questions about, of course, like, if I leave the relationship today, that person's going to do things to disrupt my immigration status. So we do a lot of safety planning around timing of leaving, timing of filing for divorce or custody and order protection, timing of filing for the immigration stuff. And so we just always, sometimes those can be complex safety and legal calculations. And so like working together with the advocacy team, the family court lawyer, and the immigration lawyer can be really, really important. So a survivor can decide what they want to tackle first and in which order they want to do it, and which step is the safest one to take first. Or sometimes I have survivors who just want to do all at once. They can totally go for it. So I think like having that teamwork between, again, advocates, family law practitioners, immigration practitioners, and of course, and first and foremost, the survivor, really can help craft what we're calling here in South Carolina, like a strong legal safety plan that integrates all of these really tough choices that survivors are facing, especially in an environment that's increasingly stressful.
Sorry about the insert here, part of the slide here. I will share with you the web page. We are going to share all the slides and presentation and the web page with all the supplemental materials. I just want to also make sure that you all do the evaluation for this webinar. This is really important for us to continue doing the work that we do. And if you need any technical assistance, you can call us, email us, and please access our web library. We are full of resources there for you.
It's really amazing.
Thank you so much, Tricia, to be here with me today.
Yeah.
Thank you. And thank you, Rebecca, for hosting this.
Thank you both, and thank you everyone for attending. I did put the link for the evaluation in the chat as well.
Okay, thank you so much. Well, thank you, everyone. Bye.
Thank you. Have a good day.
You too.